Afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I also have an immigration update. So, the Department of Homeland Security just announced that they will now be providing deferred action to certain individuals who witnessed or have been the victims of not only trafficking, but in this case, labor violations or exploitation or employer abuses. So that means that it doesn't necessarily have to be trafficking, but if the individual, if for example, if they're going after the employer for wages, or if they were underpaid and exploited, if they were threatened in any way by the employer, some of these do intersect with trafficking. But for example, say they were short on your wages, but that was the only thing that happened in this case, that could be more related to wage and hour violations, as well as employer exploitation and or wage theft, and not necessarily directly trafficking. So that is what's important here, is that this relief, where they're giving deferred action, the Department of Homeland Security is now granting deferred actions to individuals who have been victims of these kinds of things, where employer abuses, employer wage and hour violations, employer, if they didn't pay you sometimes, if they owe you payment, then if you're having these issues and these are now before an employment agency, a state, local, or federal employment agency, then this could mean that you could get deferred action. And they have stated that this will be, we can submit expedited requests for deferred action. So, what is deferred action? So, deferred action is protection from any kind of removal from the United States, and you're able to also apply for your work permit at the same time. They have already implemented a procedure to request these types of deferred action. And now, when you're applying for it, it is on a case by case basis, and you do have to meet certain requirements. One of those requirements is that a state, the agency, the employment agency, also does have to verify that you have, that there is some sort of inquiry related to any kind of employer violations going on. However, it doesn't have to be a full-fledged investigation or a full-fledged certification to be able to qualify for deferred action. So here's the situation. If you haven't reported a violation, then that is what we do. We work with reporting these types of violations to the employment agency, and then moving forward. Usually we do this in trafficking cases, but now that they have implemented this new deferred action, this could be a part of our representation to get this new deferred action. So if you haven't already, this is a possibility to then move forward to get the work with the employment federal agency, state or local federal agency, to be able to get a letter verifying that there was some sort of violation and that there is an inquiry, and then moving forward with representation to get deferred action. The deferred action usually means that you're going to get a certain period of time to be able to remain in the United States. At the same time that they're accepting these deferred action requests, they're also accepting the employment authorization application. So you're able to work legally in the United States. Now, it doesn't matter at this time, while they do consider, they do consider immigration violations, keep in mind that this deferred action is for people who don't have their status. It is for people that need relief. So don't think that you don't qualify for this because you don't have your current status. This situation is to enable you to enforce your rights, to be able to bring an employer to accountability so that you can get the wages that you are missed out on, or that they can be held accountable for any abuses that they subjected you to. This is an exciting exciting new development that has come forth over the last week. So late last week, they released this information that they now will be making this now open and ready for them to process these types of requests. So if this is something that you're dealing with, if you're dealing with this right now where you're pursuing your wages, or if you are looking at pursuing any employer violations or reporting any employer violations that have occurred, this is exactly for you, and it ensures that you're put in a protected status so that they can move forward with any kind of inquiries or investigation and to be able to get your wages and what you're due from the employer. This does not have to involve trafficking necessarily, even though sometimes it does also turn out to be labor trafficking. But if they didn't pay you, if they committed wage and hour violations, that means that they overworked you, or they underpaid you, or they didn't pay you for some weeks, or they didn't pay you as agreed. This could be a wage and hour violation, which means that you could be entitled to relief. So if that's the case, go ahead, do a consultation with me. We can talk about what your situation is and talk about pursuing deferred action requests so that you are able to get protection, get what you're owed from the employer, and also move forward with getting work authorization and a social security number so you can legally work and stay in the United States. So give us a call and we can get started right away with getting this for you. So that's an exciting piece of news. And so if you're going through something like this, or you went through something like this with an employer and you're looking to see what kind of relief you can get, especially in regards to immigration relief, but now this opens the door for you to also seek relief in to get your wages, get your justice, and get any kind of damages that are due to you based on what an employer did to you. Go ahead, give us a call and schedule a consultation, and we can talk about it and get started right away. It's best to do this. This is a new implementation, but it also means that you want to get started and beat all the traffic, right? Beat all the traffic to it so that you're at the front of the line to get this process and move forward with some sort of relief. Now I'm going to answer questions. Go ahead. I see questions here. So hi there on YouTube. It's nice to see you. I see questions coming in. Put those questions in the comments and I will answer. Can this be if the person working under the table and being mistreated? Absolutely, Jay. It does also include actually, this is what these are the individuals that they're trying to help here. The Department of Homeland Security is trying to empower individuals to be able to report this or to be able to get protection while they're going through this process to seek justice and to seek what's due to them. And also to help agencies to better investigate these kinds of issues. So if you were mistreated by an employer, if you were exploited by an employer, if you were due wages and they did not give it to you, if they underpaid you. So for example, if they paid you under the minimum wage in the state, if they overworked you, if they never paid you overtime, these all could count towards employment violations, and it could qualify you to get this type of deferred action. So give us a call. We'll talk about what your situation is and determine whether you qualify. But it certainly includes if you're mistreated and you're out of status. It is there to help you, empower you to be able to get what you deserve. Is this for under the table workers? Yes, absolutely. Does a beneficiary in the petitioner and the petitioner have to have one life insurance or both? can have separate insurance in different countries and have each other as beneficiaries. So this is really specific. And I would have to understand your case and understand what's going on with you as a couple. I'm assuming this is a couple and you're talking about marriage-based evidence. But having multiple life insurance is definitely permissible. That's something that's okay if you have it. For example, if you have it in another country and then it's also in the US, that's fine. Now, keep in mind that this is not legal advice. I'm not your attorney, and this is where it's important to get representation and at least at minimum legal advice. Sophia, absolutely. That's why I'm here. I'm here to answer questions. So go ahead and put the questions in the comments while I'm here so I can answer those questions. But I also wanted to tell you the news that the Department of Homeland Security is now they are now granting deferred action to individuals who either witness. So, by the way, this is not just for victims. This is not just for victims, but it's also for people who have witnessed violations. So, if maybe you yourself was not the person that experienced the violation, but you witnessed it, it's also available for individuals who have possibly reported violations. And then, of course, with the support of a labor agency, such as the Department of Labor or a state labor agency, with a letter stating, that yes, this was reported, or yes, they are looking into this, deferred action could be granted. And with deferred action, it means protection from deportation. It means that they will stop accruing any unlawful presence. So if you're here without status, maybe because you overstayed or you crossed the border without permission, they will not continue to count that against you. And in addition to that, you can get your work permit and social security number so that while you are on deferred action, you can also work. You don't have to be the victim of trafficking. You can actually be the witness in this case. What kind of violations? So right now if there is a labor violation involved, so that means wage and hour violations, that means they underpaid you, overworked you, abused you, exploited you. Any kind of labor violations are game in this case of deferred action. What matters here is we work. So my law firm works with the Department of Labor in these sorts of cases where we report violations. And it means that once this is reported and the Labor Department, for example, the Department of Labor provides a letter stating that this was reported and that they are now looking into this, or that they need you for further information, then this could be the basis to get deferred action. So it's not necessarily to make an entire case that you're the victim of trafficking, but to obtain that letter from the Department of Labor stating that you are needed, or the information that you have provided is necessary for them to do further inquiry into that violation. And that could be enough for you to be able to get deferred action. Of course, keep in mind that cases are different. There are all sorts of violations because the labor law in itself, immigration law is complex, but so is labor law, labor and employment law. And so whatever violation, keep in mind that it's not necessarily just limited to wage and hour violations or abuse or exploitation, but what other types of violations are there that the employer has committed, and that really is dependent on what you have witnessed as the employee or as someone who has been involved in some way with the employer. But this opens the door not only for individuals who are victims of trafficking, but also people who have been exploited by employers, and you were underpaid, you were overworked, you weren't granted overtime, and things of that nature. All right. Um, let's see. Any more questions? Put those questions in the comments. I'm here to answer your questions. So put those questions in the comments. Hi there, Sexy Kim. It's nice to see you. All right, while I'm here, put those questions in the comments and I will answer. In the meantime, I'm going to tell you how to get in touch with me. Go ahead and go to the link in the profile, and it's going to take you to the website where you'll have everything you need to get in touch. Everything from the time you call me to the consultation, everything is confidential. So that means that you don't have to worry about any of your information being disclosed or the circumstances under which you are calling. All of that is confidential. So you can go ahead and give us a call. The scheduling coordinators are available right now. So you can call right now to schedule your appointment so that we can you can get on my schedule and we can talk about what's going on and help you as soon as possible. Uh, all right, so I see some more questions. How do one know if their work permit is approved through VAWA? So usually you're able to use the receipt number. Now, if you were approved for VAWA, it usually means if your VAWA is approved, your work permit is going to come soon. If you submitted on your application that you want them to send you a work permit. If you didn't check that box, then you probably have to then go ahead and apply for the work permit separately. But if you check the box on the form when you are applying for VAWA that you want the work permit sent to you, then you should be able to just get the work permit upon approval of your VAWA. What type of hardship would allow a green card holder to have grounds to file for a person out of status? So it's going to depend. So on what your circumstances are. You know, it could be financial hardship. It could be health. Hardships related to health. It could be hardships related to employment. It could be hardship related to education. It could be hardships in regards to if you have to leave the country to relocate with the person who you're filing for. So this could be, cultural differences. Maybe if you face persecution in the country, conditions in the country, language barriers that you have to face, possible employment and financial obstacles as well. So it's just going to all depend though, which and it's not limited to just this, but it's going to depend on what your circumstances are. If your spouse is in another country, do the sponsor of do the sponsor have to go to the interview with them? No, not it's not required usually, but they will let you know in the instructions. If they want your relative to come with you, they will let you know in the instructions or in the interview letter. But usually they don't require the petitioner to attend the interview if you are going to the embassy in another country outside of the United States for the final interview. If the kid's petition got approved and the mother own is still on actively reviewing, should she wait until hers is approved before doing their filing for the NBC, or should she do it? So they're usually processed as separate cases. So one doesn't depend on the other. What matters is in the immediate case, do the kids qualify? So as long, for example, it sounds like the kids are being sponsored as step children of the spouse, the U.S. citizen spouse. And if that's the case, then they're going to it. The officer is going to look at the individual qualifications of the children. Are they the stepchildren of the US citizen? Does the qualifying relationship exist? So, and then keep in mind, that filing with the NVC, it's taking a year to a year and a half just to get interviews now. And so you don't want to necessarily delay the children, so yours can go forward first. That can that can make a year and a half case turn into a 3 or 4 year process. But it's summer. Make sure you get legal advice and representation, because your situation is also going to, the specific advice to you is also going to depend on your particular circumstances. Usually, when there's such a detailed question, there are some underlying concerns that you may have, that you may not be stating here, and the consultation is going to be the crucial place to bring that up. Is at the consultation to talk about what your concerns are and why is it you're thinking about holding off on the kids application until yours move forward. So, go ahead, schedule that consultation. Can't stress enough how important it is to invest in yourself and your process, because nobody is going to, if you make assumptions, then that can lead to a very devastating consequence. So you want to make sure that you make the right decision based on accurate legal advice. All right. Thanks, Ricky Flossie. You too. Um, all right. Great questions. I don't see any more questions, so I'm going to head out for the day. So it's Martin Luther King Day. For those of you who are celebrating, I hope you have a good holiday today. And I'll be back tomorrow as usual to be able to answer more questions and also come with great information that I think would be beneficial to you. So go ahead, tune in tomorrow. So I am coming on anywhere between noon and 12:30, just depending on how busy the day is. So you can always just follow me and look out for me between those times. I am on here Mondays through Fridays. Um, so I do see a question here. Okay, so how can I put my daughter for the tax? So that I'm not sure how that's related. So she doesn't have a social security number. So, if your daughter is not a US citizen, then it, the tax rules may be different in regards to filing taxes. So you want to make sure you get tax advice. You can always, and it's going to come down to the individual. I have to really delve deep into what your situation is to be able to properly advise. So go ahead and schedule an appointment, and we can talk about any tax issues as it relates to your immigration status. So give the office a call and let them know that you are looking for tax planning advice, and we can talk about what your issue is there. So go ahead, give the office a call. The number is listed at the bottom of the screen. All right, so that's going to be it for me today. I will be, so I see another question. I'm going to go ahead and answer it. Okay, so how long after consultation would the information be given, be sent to the email? So, it depends on whether you are going to obtain any follow-up information. Is going to be dependent on whether you qualify through the attorney for representation. But it's usually going to be given on the same day. Same day. All right. So have a great one. Thanks everyone for all your questions. Bye-bye.